I want to bring in Will Scharf right now. He's an attorney for Donald Trump, not involved in the hush money case. He's also a Republican candidate in the Missouri Attorney General's race. Good to see you, Will. So Michael Cohen testified that Donald Trump knew about the Karen McDougal reimbursement. She's paid $150,000 by American Media Incorporated, and then there was discussion of Donald Trump reimbursing them. According to Cohen, Trump said, "Don't worry, I'll take care of it." Do you think that's damaging for Mr. Trump?
You know, I'll say this. John Henry Wigmore once said that cross-examination is the greatest legal engine ever invented for the discovery of the truth. I think it's relatively easy for a witness to present a compelling case on direct after months and months and months of prep. The real test of all of this testimony will be under cross-examination. And what we have, as we've said repeatedly in court pleadings, is a witness here who is a serial perjurer, who has been found liable for perjury on numerous previous occasions. That's all going to come out. The solidity of this story will continue to weaken over time, and I think we'll see that play out in court in the coming days.
Whenever they could, the prosecution has made sure to bring forth evidence beyond Michael Cohen's word to bolster the narrative that he's telling, whether it is records of phone calls, an audio recording of Cohen speaking with Mr. Trump, a document written by Alan Weisselberg. Cohen is just in court right now, Cohen is reviewing an email from Dylan Howard saying he deleted a 2008 story, Donald Trump, Playboy Man, I guess that had been up on the whatever National Enquirer website or whatever. But in any case, what about the fact that they are bolstering wherever they can Cohen's testimony with more concrete evidence?
Well, but the question, Jake, is what they're bolstering. At the end of the day, this is not a hush money trial. This is not a tabloid trial. This is a business records fraud trial. And we barely have one iota of evidence introduced over the last 2 weeks, including today, that President Trump committed any business records fraud, much less proof beyond a reasonable doubt, which is the evidentiary quantum that the prosecution is obviously required to meet here. So to me, all of this smacks of the distraction, the smoke and mirrors campaign we've been seeing since the start of this trial. We're talking about a very simple alleged offense here at the heart of the matter, which is business records fraud. And nobody seems to have any evidence whatsoever that President Trump committed business records fraud, I believe, because he didn't, that he actually did nothing wrong here.
So are you arguing that Michael Cohen didn't pay Stormy Daniels the $130,000, that he didn't set up the shell corporations to do so, that Donald Trump didn't reimburse him, or that Donald Trump didn't know what he was reimbursing him for? What exactly are you suggesting?
So what the prosecution has to prove here is that President Trump ordered entries in his personal ledger to be made, that those entries were not just inaccurate, but that were fraudulent, that were made with fraudulent intent. And they also have to prove that the reason for those fraudulent business entries was to cover up another felony offense. Now, the felony offense that they're alleging is this somewhat nebulous election-related conspiracy. But at heart of this case is still that business records fraud issue. Did President Trump order entries to be made in his personal ledger with fraudulent intent to cover up another crime? And I just don't think we've seen any evidence of that so far from Cohen or any of the other witnesses. And unless the prosecution can prove that basic fact beyond a reasonable doubt, this case should be a directed acquittal. If it makes it to the jury should certainly acquit. That's, I think, the situation that we're dealing with here. We have this smoke and mirrors campaign by the prosecution to pollute the jury's understanding of this case with a lot of irrelevant, highly prejudicial material. But we haven't really heard much about what's at the core of this case, which is business records fraud.
All right, Will Scharf, thank you so much for your time today. Really appreciate it. Attorney George Conway is back here with us. He is a donor to Biden's reelection campaign, we should note. George, your reaction to Will Scharf. I could sense that you didn't agree with him.
Yeah, I mean, I think a lot of it is nonsense. I mean, I think if he gets a hung jury here, and I think he's not going to get an acquittal, I think it's going to be because somebody does not make that connection between Trump and these records. But the problem for the defense is he signed some of the checks. He paid very close attention to things that were expenditures made on his behalf. We heard the testimony about Madeline Alstahar and the $600 for whatever it was, and we hear, he looked at these things, the backup from the checks that he was signing. They had backup on it, the fake invoice, what it was for. And the point about it is it's not about the Trump talking points here, which you hear from a lot of the lawyers, seems to be basically that unless he was there at the computer and he clicked that on the drop-down menu, like he did it himself, then, beyond a reasonable doubt, acquittal. It's just not the case. The statute says, did he cause this to happen? And if you look at the entirety of the evidence and not look at the way defense lawyers, and spinmeisters look at it, which is to take every little piece and not connect the dots, you can't figure out what the alternative theory is, the alternative theory that would allow a jury to say, well, we have all these facts, they're not really disputed. I think we heard one of the Trump lawyers say, the facts really aren't disputed. What's the innocent explanation for this? And there is none.